Um, so yeah, this was a fascinating topic to research and obviously changing very, very rapidly. I'm fascinated by the bombardment of daily articles on AI that I get, and just I put a few in here just because these are from this week. This was just a one in Becker's about the nursing staff at HCA updating their contract to include the clause about how far AI can go into their daily work. Um, and some really pretty upsetting cases like this one, which was in the New York Times this past Wednesday, about this very unfortunate 14-year-old boy who used AI to create uh, a woman who he gave the character one of the characters in Game of Thrones. He gave her the name and sort of a lot of attributes from her, and eventually ended up spending all of his time with her with this bot, this AI bot, and he decided that it would be better to be with her. And he asked it if he could come home to her, and it said yes, please do. And then he got his father's gun and killed himself. So I think it's interesting to see how much AI can help us, but also how much danger there is associated with it. Um, this was just an interesting example of how much data is generated now and how AI can be very helpful to evaluate it. Um, this was just a brief article about data and health data in 2013, 153 exabytes of global health. I had to look that up, but an exabyte is a quintillion bytes or a billion gigabytes. And I thought this was interesting. All the words ever spoken by humans could be stored in 5 exabytes. So there's an awful lot of data to analyze, and obviously AI can do that in ways that our human brains can't. Some of the areas where AI is in use in healthcare now, um, for example, diabetic retinopathy screening. I thought this was quite interesting. I'm obviously not an ophthalmologist, but this allows the system to analyze whether there's sufficient evidence of retinopathy for a referral to a retinal specialist or not. Um, some of the other things, and this was mentioned earlier in one of the other talks about accessing more rural areas. Was a application in Kenya looking to see how they could reach mothers for postpartum depression, because the access to mental health providers is so difficult, especially in rural areas in Kenya. Um, and we heard earlier from Dr. Carrillo, great talk about the applicability of AI in surgery in the OR and postoperative care and discharge. And that is sort of near and dear to me, since I mostly do neurosurgery, about ways to improve both intraoperative and postoperative care. So really, I think it's a double-edged sword, right? So we either end up in Hawaii or wherever this picture is, um, or we end up here. Um, and I'd rather the former than the latter, and I'm sure everybody else would too. So some of the areas of liability that I'm going to go over quickly here: regulatory landscapes, torts, and private cause of action, standard of care. These are all things that we've touched on today. Responsibility, informed consent, bias, documentation, a few case studies that I found very interesting, and just the FDA's take on it. So I think it's obviously important for all of us to be aware of the current statutory and regulatory requirements for using AI, but also that whether the FDA decides to actually fully regulate AI software and require their registration with the FDA, that certainly could change things. Um, we touched on this. Dr. Sambar was great earlier today talking about, well, you can't sue a machine, so you can only sue people. But that's sort of sort of begs the question of, can you sue the people who develop it, the developers, and how do you sue them, and whether that falls under, medical malpractice or specifically product liability. Um, so, and of course, acts and omissions of the artificial intelligence system itself. Um, so yes, just like I was saying, is there liability for the developers of the AI, those who are selling the software to systems, using them and employing them, those systems that mandate AI use, and of course, liability to the provider relying on the AI. And where do these theories of liability apply? Standard of care is particularly interesting because generally it's defined by what a reasonably competent healthcare provider would do under similar circumstances. But by integrating AI tools, you can redefine that standard. So if AI is considered superior in certain diagnostic scenarios, the failure to use it might be considered negligence. Conversely, if an AI system makes an incorrect diagnosis, you have to decide whether the clinician appropriately relied on it or should have used their own judgment. And that, of course, leads to new types of expert witness requirements, which I'm going to touch on a little bit later in one of the cases that I'm going to talk about. Again, if the AI gives you a faulty recommendation, is the liability purely on the healthcare provider, or is it on the healthcare provider and the institution, et cetera, et cetera? And there's certainly a potential chain of liability. Informed consent, again, for patients, they really need to know whether a provider, whether a surgeon, whether a hospital system is relying on AI, and to what extent it's relying on AI to diagnose and treat them. Failure to inform a patient could certainly generate a malpractice claim for lack of informed consent. I threw these up. Again, Dr. Correa was great earlier talking about some of the other systems at Duke. But this is systems that are in use at most hospitals, if not all. So, I mean, complex robotic systems like the Da Vinci, or a lot of, in my area, there's always something new every week almost in intraoperative stereotactic equipment especially for spinal surgery, but also for cranial surgery. And again, just going back to the liability issue, who's at fault, and is it regular medical malpractice, or is it product liability? So, and that the cases I'm going to go over are, of course, typical in that they're confusing because they're conflicting. Our last speaker talked about bias and discrimination, which I think is really important. Depending on what the AI system is built with, if it's built with massive amounts of information from a community that doesn't look, sound, speak like your community, there are going to be some serious discrepancies between what AI generates for you and what may actually be going on, including these, and possibly leading to legal actions under discrimination laws. So, and just like our last speaker said, documentation, transparency, very, very, very important for interacting with our patients with this technology. So there aren't a whole lot of cases, but there are some. And as you'll see, the courts are very conflicted as to how to deal with this. And the first case I came across, which was interesting, from Virginia, is about a patient who had surgery, had a gallbladder surgery, as a 25-year-old, and was admitted to the hospital by his physician. And his physician, Dr. Booth, entered all the orders on April 5th at 4:34 in the afternoon and hit enter. And one of her orders was for pulse oximetry on this gentleman who unfortunately had pretty bad sleep apnea. And the Cerner system asked her how often she wanted to renew the order, and she clicked on daily. And that defaulted the system to start the following day with pulse oximetry, not at the time of admission. But that was not shown to her on her screen. So, and of course, like a lot of these cases, because they're cases, there's usually a bad outcome. The nursing staff were fairly good at getting their vitals, but skipped the morning vitals at 9 a.m. And at 10:30, the physician showed up to evaluate her patient, and he was essentially in respiratory arrest. So I thought I'd ask Marissa Tomei to help us explain, what really happened here. And like I was saying, there was a flaw in the order entry screen because it displayed the current date and time as the start time for all the orders, but that's not actually what the system was doing. The problem here too was that the sequence of events was hardwired into the EMR, which meant that neither the hospital system nor the provider could do anything to change that, the way that the orders were processed by the system. So the case led to several different claims. One, medical malpractice, and two, product liability, negligent design of the software, and then a failure to warn of the negligent design. Now, this was the expert witness stuff I was talking about. These were several of the expert witnesses called and challenged at trial. A professor of biomedical informatics and another physician who was involved with clinical informatics and biomedical informatics. So, not that anybody needs reminding of this, but obviously to prevail on a negligent design claim, the plaintiff had to show that the defendant legally recognized duty to design the product to ensure it was reasonably safe for the purpose for which it was intended. And there's several ways to do that in Virginia. Now, the trial court decided on summary judgment for the defendant, Cerner, which was interesting. On appeal, though, the appellate court vacated that decision and remanded for trial on both claims against Cerner. And this was interesting because during discovery, it turned out that Cerner had been on notice from an almost identical claim years prior to this case about this very defect in their software. And so the court said, well, hold on a second. You're on notice. You've had this problem before. So again, your system was designed poorly and you failed to warn. So that was, I found a fascinating case, court allowing that to proceed on the product liability claim. This case is from Texas. Now, this was interesting because this, without going into a whole lot of details, this is a patient who was injured during sinus surgery. The treating physician employed something called a navigation balloon dilation system. I'm not an ENT, so I can't tell you much about it, but it was an AI-enabled device. They sued for malpractice, but as a separate matter, wanted to pursue a pre-trial discovery deposition with the company making this in order to figure out where the programming was done and who did it. And the long and the short of it is that the trial court found for the plaintiff, and ordered a pre-trial deposition. But the Court of Appeals reversed, and just making it much harder for the plaintiff to go ahead with suit and making it more expensive. So that system, not so happy with bugging AI companies that work with AI systems and sell them to hospitals and providers. This is a case I came across at actually a colleague of mine is working on here in Missouri, and involves the company Lyft. The details of the case are actually irrelevant, but what I found interesting is that it's a product liability suit, but and it's actually on appeal right now. The trial court dismissed it because they said um, the Lyft app isn't a tangible product because it's not a tangible product, it can't be subject to product liability. Um, so that's on appeal right now. This is a very recent case, as you can see, just this year. So I'm kind of curious to see what happens there. That's just obviously determining whether something that's intangible can still be subjected to product liability. So this brings up some interesting questions. Will there be more cases filed? Hybrid cases, medical malpractice and product liability? And how does that impact the jurisdiction, especially if there's FDA approval required for the product? So it brings up more questions, like everything in law, about getting a second bite at the apple. What if you decide to sue for malpractice first and then you win, and then you decide, well, now I'm going to file for a product liability claim, and you can go back. And especially that may be interesting if the statute of limitations are different. Now, number two over here is interesting because it may create more problems for defendants who may, if they're being sued initially just as the providers, they may want to join the EMR and the AI companies in an attempt to reduce their own exposure, which could certainly up the ante for both sides. So the long and the short of this is we need to establish clear guidelines for when and how AI tools should be used. We need appropriate training and education. And then documentation. I think everybody has said that today. Documentation. So it appears, at least for now, courts are a little bit unsure of how to deal with these product liability claims with software and AI. And it certainly, if they end up siding more with the plaintiffs, there certainly could be this opportunity for a second bite of the apple. This will raise costs for both sides in terms of expert witnesses, because now you'll need people who are experts in AI, which is certainly not me. Informed consent issues that arise or lack of informed consent may lead to more suits. And then, of course, the bias and discrimination that we talked about earlier is very important for hospital systems when they're choosing a product to implement and where they're choosing to implement it. I put this in here just for everybody. This is a link to the latest FDA update on regulating AI. There, obviously, the jury's still out on that in terms of how much regulation and what they're going to regulate. But I think this is a fascinating and emerging field. And frankly, I can't wait for the meeting in February, because I think we'll be able to expand on this quite a bit. And I've really enjoyed all the speakers today, and thank you for listening.